Maryland rental laws outline the rules in the state regarding lease agreements and evictions. We'll examine the laws for standard lease agreements, month-to-month lease agreements, and evictions. Standard lease agreement. A standard lease outlines the terms between a landlord and tenant for the renting of property. A standard lease is commonly a one-year fixed period and is the most widely used rental contract. Month-to-month lease. A month-to-month lease is an agreement between a landlord and tenant that renews automatically every month and terminates upon notice by either party. In Maryland, the notice must be provided by the landlord or tenant a minimum of 30 days prior to termination as required by law. Required disclosures. In Maryland, the landlord is required to provide the following disclosures as part of the lease agreement. Identification. Whoever is managing the unit, whether it be an agent or the owner themselves, they must provide the tenant with their name, address, and phone number. Move-in checklist. This form should be attached to the lease and must be filled out by the tenant within 15 days of moving in. Habitation. A statement must be included in the lease agreement that states the property will be in a condition that permits habitation and lists the tenant's responsibility as to heat, electricity, gas, water, and any necessary repairs. Security deposit receipt. Landlords must furnish a receipt for any security paid by the tenant. Landlord access. In Maryland, the landlord is not required to give notice before entering the property for repairs or any non-emergency reasons. Security deposit laws. In Maryland, the landlord can charge a maximum of 2 months security. The money must be returned to the tenant within 45 days of vacating the property. Eviction laws. There are 3 legally accepted causes for eviction in Maryland. Non-payment of rent. In Maryland, the landlord may begin a process called summary ejectment, which begins the process of eviction immediately upon the rent being late. The notice should be given to the tenant when the landlord has received an ejectment case number and a date from the sheriff when the eviction shall take place. Imminent danger. If the tenant poses a threat to themselves or other tenants on the property, the landlord may give the tenant a 14-day notice to quit. If the tenant refuses to comply after the allotted 14 days are up, the landlord can issue a summons through the courts immediately. Non-compliance. If the tenant breaks any portion of the lease other than late rent, the landlord may give the tenant a 30-day notice to quit. The tenant then has 14 days to comply with the lease. If they do not cure their violation in 14 days, they must vacate within 30 days.